The Supreme Court just unsealed a case that nobody saw coming, and Trump has exactly 60 days to respond before facing consequences that could end his political career permanently. We're not talking about one of the high-profile cases everyone's been watching where oral arguments are televised and every legal filing makes headlines. This is a case that's been proceeding in complete secrecy under seal for 8 months, involving criminal conspiracy charges that legal experts are calling the most airtight prosecution Trump has ever faced. When the Supreme Court unseals a sealed indictment, sets a compressed response deadline, and schedules expedited review that bypasses normal appellate procedures, you know the legal noose is tightening in ways Trump cannot escape. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what is this mysterious sealed case? On March 12th, the Supreme Court issued a brief order unsealing United States v. Donald J. Trump, a criminal case that has been under seal since July 2024 at the request of federal prosecutors who argued that keeping the case sealed was necessary to protect an ongoing investigation and prevent witness tampering. The newly unsealed filings reveal that Trump has been indicted on 7 counts of criminal conspiracy to defraud the United States, obstruction of justice, and witness tampering related to his attempts to overturn the 2020 election results. But here's what makes this case different from all the others. The indictment includes 3 cooperating witnesses who were members of Trump's inner circle, all of whom have provided detailed testimony under oath about Trump's direct involvement in criminal schemes. The case includes documentary evidence that prosecutors claim proves Trump knew his actions were illegal and proceeded anyway. And the Supreme Court's order specifically notes that Trump must respond to the charges by May 11th or face immediate arrest warrants. This isn't another legal proceeding that will drag on for years. This is a case on an accelerated timeline with criminal consequences that are imminent and unavoidable. Here's what's been happening in secret while everyone focused on Trump's other legal battles. Federal prosecutors have been building this case methodically since early 2024, using a grand jury that met in complete secrecy. The case remained sealed because prosecutors argued Trump has a documented history of attempting to intimidate witnesses. According to the newly unsealed documents, the grand jury heard testimony from 3 key cooperating witnesses. The first is a former White House senior advisor who documented conversations where Trump explicitly discussed plans to submit fake electoral certificates. The second is a former campaign attorney who testified Trump directed him to make false statements to state legislators about election fraud, despite being told the claims were baseless. The third is a former DOJ official who documented Trump's attempts to pressure the department to issue false statements claiming the election was rigged. All 3 witnesses have provided contemporaneous notes, emails, and text messages corroborating their testimony. Smash that like button if this is making sense so far. The unsealed indictment doesn't just allege crimes, it includes specific evidence prosecutors claim establishes criminal intent beyond reasonable doubt. Count 1 alleges conspiracy to defraud the United States by using false electoral certificates. The indictment includes emails showing Trump was told by his own attorneys that the fake elector scheme was illegal, and Trump's response directing them to proceed anyway. Count 2 alleges obstruction of justice for Trump's attempts to pressure state officials to change vote tallies. Counts 3 through 7 allege witness tampering for Trump's communications with potential witnesses telling them not to cooperate. What happened when the Supreme Court unsealed the case on March 12th reveals just how serious the legal jeopardy has become. The court's order unsealing the case includes several extraordinary provisions that severely limit Trump's ability to delay or obstruct the proceedings. First, the order sets a 60-day deadline for Trump to file any motions to dismiss or respond to the charges, with no extensions permitted for any reason. Second, the order states that if Trump fails to respond by the deadline, the court will issue arrest warrants and order him held without bail pending trial. Third, and most critically, the order establishes an expedited appellate schedule where any appeals Trump files will be heard and decided within 30 days, eliminating the usual multi-year appeals process. Drop a comment right now if you saw this coming. I read every single one. The most devastating aspect of the unsealed case is the cooperating witness testimony. According to legal analysts who reviewed the unsealed filings, the three cooperating witnesses have all signed plea agreements where they admitted to their own criminal conduct and agreed to testify truthfully against Trump in exchange for reduced sentences. This means that if Trump goes to trial, he'll be facing testimony from his own former advisors who have already admitted under oath that they participated in criminal schemes at Trump's direction. When your own co-conspirators flip and provide detailed testimony about your personal involvement in crimes, your legal defense options become extremely limited. The standard defense of claiming you didn't know the conduct was illegal collapses when witnesses testify that they specifically told you it was illegal and you ordered them to do it anyway. This isn't the first time Trump has faced criminal charges, but the sealed case has several elements that make it uniquely dangerous. The January 6th prosecution in D.C. federal court has faced delays as Trump's attorneys filed numerous pretrial motions challenging everything from venue to presidential immunity. The classified documents case in Florida has been similarly delayed by a Trump-appointed judge who has granted every defense request for postponement. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. The sealed Supreme Court case is structured to prevent those delay tactics. Because the case was under seal for 8 months while prosecutors completed their investigation, Trump cannot claim he needs more time for discovery or to prepare his defense. All the evidence has been collected, all the witnesses have testified, and the indictment is ready for trial. The Supreme Court's expedited timeline eliminates Trump's primary legal strategy of delay. He must respond within 60 days. Any appeals are decided within 30 days. And if he's convicted, sentencing happens immediately with no opportunity for lengthy post-trial motions. The pattern is unmistakable. When prosecutors have overwhelming evidence, including cooperating witnesses and documentary proof of criminal intent, and when courts impose strict timelines that prevent delay tactics, defendants face a choice between pleading guilty and negotiating a sentence or going to trial and risking maximum penalties. So what specific evidence makes this case so dangerous for Trump? According to the unsealed indictment, prosecutors have obtained text messages between Trump and senior advisors discussing the fake elector scheme in detail. One message allegedly shows Trump writing that he knows the fake certificates aren't real electors, but that submitting them will create enough chaos to stop the certification. Another message shows Trump acknowledging that state officials have told him the election results are accurate, but saying he doesn't care and wants them changed anyway. These messages directly establish that Trump knew he lost the election, knew the fraud claims were false, and proceeded with illegal schemes anyway. Here's what prosecutors say is the smoking gun. The indictment includes an email from December 2020 where Trump's own campaign attorneys told him explicitly that submitting fake electoral certificates to Congress would constitute fraud and could result in criminal charges for everyone involved. Trump's response, according to the indictment, was to tell the attorneys to find different lawyers who would do what he wanted. That email exchange destroys any possible advice of counsel defense because it shows Trump was warned the conduct was criminal and chose to proceed despite the warning. Don't go anywhere. The most explosive part is coming next. Prosecutors also obtained recordings of phone calls Trump made to state election officials where he allegedly made explicit threats. In one call to Georgia Secretary of State Brad Raffensperger, which was already public, Trump says he needs Raffensperger to find enough votes to change the outcome. But the indictment reveals previously sealed portions of that call where Trump allegedly threatens Raffensperger with criminal prosecution if he doesn't comply. In another call to an Arizona election official that was not previously public, Trump allegedly offers a presidential pardon if the official agrees to decertify the state's results. Those calls constitute bribery, extortion, and obstruction of justice. This puts Trump in absolutely impossible legal jeopardy. On one side, he faces 7 felony counts with overwhelming documentary and testimonial evidence, including cooperating witnesses who were his own advisors. Legal experts reviewing the unsealed indictment say the evidence of criminal intent is stronger than in any previous Trump prosecution. On the other side, he faces a Supreme Court-imposed deadline that eliminates his ability to delay proceedings for years through appeals and procedural motions. And here's the catastrophic reality. If Trump is convicted on even one count of conspiracy to defraud the United States, Federal sentencing guidelines suggest a prison term of 5 to 7 years. If convicted on all 7 counts, he could face 20 to 30 years in federal prison. At his age, any substantial prison sentence is effectively a life sentence. The legal stakes have never been higher. Legal and constitutional scholars are calling this the most significant criminal prosecution of a former president in American history. Andrew Weissman, former federal prosecutor who served on the Mueller investigation, told MSNBC that the unsealed indictment reveals a level of detailed evidence he's never seen in a case against a major political figure. When you have contemporaneous documents showing the defendant was warned his conduct was illegal, cooperating witnesses who participated in the schemes at his direction, and recorded phone calls where the defendant makes explicit threats and offers bribes, that's what prosecutors call a perfect case. There's no ambiguity, no reliance on circumstantial evidence, and no way to claim misunderstanding. Renato Mariotti, former federal prosecutor, added that Trump's standard delay tactics won't work against the Supreme Court's expedited timeline. The court has made clear that this case will proceed quickly and that Trump's only options are to respond substantively to the charges or face arrest. You can't delay your way out of a Supreme Court order with a fixed deadline. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative legal analysts acknowledge the strength of the prosecution's case. George Conway, conservative attorney and frequent Trump critic, wrote that the unsealed evidence appears to establish every element of the charged crimes beyond reasonable doubt. If the cooperating witnesses testify consistently with what they told the grand jury, and if the documentary evidence is as described in the indictment, Trump's conviction is virtually certain. The immediate impact of the unsealed case is creating panic in Trump world. Trump's legal team has just 60 days to file a response, but according to legal experts, there's no obvious defense to the charges given the strength of the evidence. Trump cannot claim he didn't know the conduct was illegal because his own attorneys told him it was. He cannot claim the evidence is fabricated because it includes his own text messages and recorded phone calls. He cannot claim the witnesses are lying because multiple witnesses corroborate each other's testimony and documentary evidence supports their accounts. Second, the Supreme Court's accelerated timeline means Trump will face criminal trial within months, not years. If the trial proceeds on the court schedule, Trump could be convicted and sentenced before the 2024 general election, fundamentally altering the political landscape. Finally, the seriousness of the charges and the strength of the evidence may convince some Republican officials that continued support for Trump is politically untenable. When Trump faces imminent conviction on felony conspiracy charges with cooperating witnesses from his own inner circle, defending him becomes defending a convicted criminal rather than defending a persecuted political figure. Drop a comment below with your thoughts. But beyond the legal crisis, this is about whether former presidents can attempt to overturn election results through criminal schemes and face accountability. The unsealed case alleges Trump engaged in a coordinated conspiracy involving fake electoral certificates, threats to state officials, and attempts to corrupt the Justice Department. If that conduct results in no conviction because Trump delays proceedings indefinitely, the entire framework of accountability for election subversion collapses. Trump's remaining allies are in turmoil. Republican officials who defended Trump must now explain supporting someone facing imminent criminal trial on charges of conspiring to overturn an election. Trump's response has been defiant but legally weak. He's claimed the case is politically motivated and attacked the prosecutors, but notably absent is any substantive challenge to the evidence described in the indictment. Stay with me because what comes next will completely change how you see this. Here's what makes the sealed case so devastating. For months, Trump and his supporters claimed he was the victim of political persecution and that all the cases against him were weak and would eventually be dismissed. The unsealed indictment reveals that while public attention focused on other cases, prosecutors were quietly building an airtight conspiracy case with cooperating witnesses, documentary proof, and recorded evidence of Trump committing crimes. The element of surprise combined with overwhelming evidence has left Trump with no viable defense and no ability to delay. This goes far beyond whether Trump faces prison time. It's about whether attempting to overturn democratic elections through criminal conspiracy can be successfully prosecuted, even when the defendant is a former president with significant political support. If Trump is convicted, it establishes that no one is above the law and that election subversion will be met with serious criminal consequences. If Trump evades conviction despite the evidence described in the indictment, it signals that politically powerful figures can attempt coups without facing real accountability. The stakes are existential for democracy itself. If this blows your mind, hit that like button right now. Here's the situation. The Supreme Court unsealed a criminal case that's been proceeding in secret for 8 months. Trump faces 7 felony counts of conspiracy to defraud the United States. 3 cooperating witnesses from his inner circle have provided detailed testimony. Documentary evidence includes Trump's own messages acknowledging the illegality of his schemes. The Supreme Court has imposed a 60-day response deadline with no extensions. Any appeals will be decided within 30 days. Trump faces trial within months and potential conviction before the 2024 election. His delay tactics have been eliminated and his legal options have run out. Keep watching because this case is accelerating. Trump's response is due May 11th. Legal experts are analyzing whether he has any viable defense. Prosecutors are preparing for trial, and political observers are watching to see whether Trump can survive criminal conviction from his own cooperating witnesses. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. The Supreme Court has unsealed a criminal case against Trump that includes cooperating witnesses, documentary evidence, and recorded proof of criminal conspiracy. Trump has 60 days to respond or face arrest. The case proceeds on an expedited timeline that eliminates delay tactics. Legal experts say the evidence appears overwhelming. Trump's inner circle has flipped and agreed to testify against him. This isn't a case Trump can tweet his way out of or delay indefinitely through appeals. This is criminal prosecution with cooperating witnesses, documentary proof, and a Supreme Court-imposed deadline that puts Trump on an unavoidable clock. Either Trump mounts a successful legal defense against evidence that experts say is overwhelming, or he faces criminal conviction and substantial prison time. What happens in the next 60 days will determine whether a former president can be held criminally accountable for attempting to overturn an election. The unsealing is complete, the clock is running, the witnesses are cooperating. Now we wait to see if the criminal justice system can convict a former president when the evidence is this strong and the timeline is this compressed. The stakes for American democracy have never been higher. The evidence has never been more thoroughly documented, and the legal deadline has never been more absolute. Pause for a second and hit that like button if you're finding value in this coverage of the most consequential sealed case in modern American legal history.